Good afternoon, everyone, and welcome. I'm Laura Grease, the Director of Claims here at PCH Mutual, and I want to thank you for taking the time to join us today for this important webinar on arbitration. In the claims environment, our goal is to achieve the best possible outcomes for the company and for you, our members slash policyholders. That means efficient and definitive resolution of claims. To guide us through this critical area, we have two of the industry's most recognized leaders in healthcare litigation and risk management. It's our pleasure to introduce Kathleen Walker and Jeffrey Healy. Kathleen is the co-managing partner in the Los Angeles office of Lewis Brisbois, and she has helped us resolve many claims. Those claims have often been in litigation, and Kathleen's going to tell you firsthand how it probably would have been much better to have those claims in arbitration. Still, she effectively resolved those claims. She is going to introduce us to her partner, Jeffrey Healy. He's an expert in long-term care litigation and arbitration, and he's going to explain this process to us. Kathleen?
Thank you, Laura, so much. Jeff and I are really pleased to be here, and we value working with the PCH members. It's always nice to get to defend people who are on the front line for providing care. As Laura mentioned, Jeff and I are at Lewis Brisbois. I am the chair, one of the chairs of the National Healthcare Practice. Our law firm is a big law firm in over 55 states, but we do provide you with personal attention when we're retained to help. I've been a litigator for over 34 years and devoted my entire legal career to helping people like you, those who care for others. And my job is to help you navigate the litigation process, to defend your interests, to fight back against the allegations being made against you, to push back against those attacking you and the care you and your staff provided. We understand it's always disheartening when you have tried your best to care for someone and then end up with a lawsuit being filed against you. It feels like a betrayal. No one wants to be sued. No one wants to go before a jury of strangers at a courthouse and have accusations made against them publicly. Today's presentation has an important message for you and provides you with a valuable way to reduce risk before you get sued. The importance of before you get sued. Today is a call to action. The use of an arbitration agreement by you as part of the admission process is a game changer. As you will learn today, having someone sign a simple piece of paper could literally save you millions of dollars in the event that you get sued. Without a doubt, I can say after having defended thousands of senior claims for over 3 decades, a signed arbitration agreement is the best way for you to reduce risk. It's my privilege today to introduce you to my partner, Jeff Healy. Jeff has been an attorney for over 2 decades and has worked alongside me at Lewis Brisbois for over 23 years defending senior care providers like you. He is a recognized expert in California in drafting and enforcing binding arbitration agreements and has given presentations up and down the state to many, from large operators to very small family-owned RCFEs. Jeff has argued more hearings to compel arbitration and fight the arbitration issue than any other attorney in this state. You're in it for a treat today. Listen carefully, enjoy the presentation, and put into practice what you learned today to reduce risk. Without further ado, please meet Jeff Healy, my partner, who is your presenter today.
Thank you, Kathleen. Thank you for those kind words. Hello, everyone. I am Jeff Healy. I have had the pleasure of working at Lewis Brisbois Bisgard and Smith for 23 years now, and the vast majority of that time has been in the defense of long-term care communities, RCFEs, and skilled nursing providers. I have been on the front line of enforcing arbitration agreements since day one, and the law has changed dramatically from 23, 24 years ago to today. And as Kathleen indicated, Arbitration agreements are indeed game changers. They are a tool for us to use to mitigate risk and to even the playing field. What I'm hoping to achieve today is for you to have a better understanding of what arbitration agreements are, why they are important, and what you need to do to increase the likelihood of having those documents be enforceable by a court when the time comes, if it ever comes, that we need to try to move a lawsuit into arbitration. I want to start off with a cute little video about what arbitration is and why it is important. Please enjoy.
High, especially in sensitive cases like those involving vulnerable adults in residential facilities. The outcome? A huge unexpected verdict. Juries, swayed by emotions and personal stories, may issue runaway verdicts that could have devastating financial consequences for long-term care facilities. But what if there was another way? Arbitration can offer a solution where a neutral third party, not a jury, makes the final decision. In arbitration, decisions are based on facts and law, not emotions. Entering into an arbitration agreement with your resident upon admission helps prevent runaway verdicts and provides a fair, more predictable process for both sides. PCH provides a sample arbitration agreement through PCALIC's website. Get counsel to confirm the sample agreement is valid in your state and in compliance with the local rules to ensure the proper party signs it. Arbitration agreements, helping you avoid costly, unpredictable court battles.
So an overview of our presentation today. What is arbitration? Why is arbitration important? And how to ensure that the arbitration agreement is enforceable. Those are our goals for today. So what is arbitration? Arbitration is a form of private dispute resolution. What does that mean? That means that disputes are resolved outside the court system. So the dispute will not be heard before a judge and a jury. Instead, disputes are heard by an arbitrator, which is typically an independent third party, typically also a retired judge or someone who has experience handling long-term care cases. And again, not heard by a jury. Parties can conduct discovery. They can give an opening statement just like you would if you were in a courtroom. And they can present evidence to the arbitrator just like you would present evidence to a judge if you were in a courtroom. The difference is we're not in a court of law and we're not before a jury of 12. Instead, we are before typically a single arbitrator that has experience handling long-term care cases and understands the law and is better suited to hear these long-term care type cases. Arbitration is less formal than court, so the parties have input as to when and where the arbitration will take place. And another key benefit of arbitration is that it's private. Therefore, the sensitive health information will not be open to the public. What a lot of people don't recognize or understand is that when you file things with the court or the judicial system, those documents are public record. So if you attach anything by way of a medical record that contains sensitive medical or private information, the general public can get that by requesting the file through the judicial or court system. But in arbitration, it's private. So your sensitive health information is not open to the public. Arbitration is good for both sides. It's fast, it's fair, confidential, and it's usually less expensive over the life of the case. Disputes in arbitration are usually resolved much faster in arbitration, whereas the court system can often take years to complete. And that's particularly true here in California, where a lot of times it will be 2 to 3 years before a case ever makes its way to trial. And when a case is active for 2 or 3 years, hundreds of thousands of dollars in attorney's fees are generated by the other side, which they are invariably going to try to seek to recover as damages in these lawsuits. So the quicker a dispute is resolved, the less expensive it is for everyone involved. Plus, in long-term care settings, oftentimes we are dealing with elderly population. And if they can get a resolution to their dispute quicker, it's often in their best interest as well. Also in arbitration, the parties get to pick the arbitrator. So why is that important? An arbitrator is the person who is going to be deciding the merits of the case. They're going to be weighing the evidence and deciding if the community or the facility did anything wrong, or if everything was performed up to the standard of care. The arbitrator you're going to want somebody who understands long-term care, who's well-versed in the law, not somebody that the court clerk office appointed and doesn't have a lot of experience handling these kind of cases. So by getting to pick the arbitrator, the parties have an element of control where they get to have input as to who, by way of looking at their resumes, is qualified to handle and hear these sort of legal matters. So that is a very important aspect of arbitration. Arbitration hearings are also arranged at agreed upon times and places to suit the parties and the witnesses, as opposed to what is convenient for the Superior Court. So why are we doing this presentation to begin with? Why is arbitration important enough for us to do this webinar? Because arbitration is the best risk management tool that you have at your disposal. And as Kathleen indicated, having a resident sign a single piece of paper could potentially save you millions of dollars. And that's not an understatement. Litigation comes with a high level of risk and a high level of cost. And having an arbitration agreement in your file that is signed by the resident or the appropriate party can help mitigate that risk and ensure that you don't have that sort of multi-million-dollar exposure that unfortunately resulted in some of the following cases. Morris versus Longwood Management Corporation. That case involved a pressure ulcer that became infected, but notably, the jury verdict was $12.8 million. In 2013, Schlesinger versus Grandview Palms is a fall with a fracture of a right hip, which fall cases, I'm sure, you tend to see from time to time because you cannot prevent all residents, particularly those who have the ability to ambulate, from falling as they age. This case resulted in a verdict of $5.4 million. Tanner versus Colonial Healthcare is another fall case. And as a result of the immobility following the fall, a decubitus ulcer was developed. The jury awarded $21.9 million. Levenstein versus Eschaton in 2019 involved medication errors. Sometimes we will see arguments from the plaintiff side or the family suing that you didn't provide medication consistent with physician orders. Either you didn't provide it at the right time, or you were off by 30 minutes to an hour or an hour and a half, or you were medicating somebody because you were trying to control them by sedating them. Well, that's the issue that presented itself in Levenstein versus Eschaton, and the verdict was $42.5 million, with $35 million of that being punitive damages. So these lawsuits that you will see or potentially see, they're not only suing for negligence. Oftentimes they will throw in a cause of action for elder abuse and neglect. And the elder abuse and neglect cause of action, if they prove it, entitles them to recover their hundreds of thousands of dollars in attorney's fees that are generated over the life of the case. But it also entitles them to the ability to recover punitive damages. And punitive damages are damages to punish the defendant or the company or the corporation for what the jury believes to be inappropriate or bad behavior. And the family or the attorney for the family will present the evidence in a way to the jury to make your community look as bad as possible, in the hopes that the jury will be angry with your community and will award them punitive damages. So we want to be in an environment where emotion is taken out of the equation. We want to be in an environment where the person deciding whether or not we did anything wrong and whether or not damages are recoverable is somebody who understands the law, who understands the facts, who isn't swayed by emotion and can look at the lawsuit objectively and decide, was anything here done wrong? The video that played earlier, I think a few folks indicated they had a hard time hearing it, or maybe the sound wasn't playing. But what's important about that video, and it ties in well with these verdict slides, is that in a courtroom, emotions can run high, especially in cases involving vulnerable elderly adults in residential care facilities. Jurors can be swayed by personal stories and can allow fear and anger to cloud their judgment. Jurors, which is in the jury system, tend to have a difficult time understanding what a residential facility can and cannot prevent. For example, not all falls can be prevented. Yet when somebody does have a fall in a retirement community or a long-term care facility, jurors invariably think there's something you could have or should have been able to do that would have prevented that fall from happening. But we all know from doing this, as long as we've been doing it, that not everybody needs one-to-one observation. And even if somebody is on one-to-one monitoring or escorting to and from the dining room, a fall can still happen just like that, super quickly. And sometimes there's nothing you can do to prevent that fall from occurring. But juries don't tend to see it that way. At least they have a hard time seeing it that way. They tend to view it that my loved one is in your facility and you are aware that they're a fall risk, and they fell. And they fell because you did something wrong. And that is the theme that oftentimes the attorneys for these suing families put forward. And jurors oftentimes are swayed by that. The outcome before a jury can result in runaway jury verdicts, again, resulting in multi-million-dollar verdicts that have a devastating financial consequence for long-term care facilities. And that is what we are hoping to avoid with each of your facilities or communities. In arbitration, decisions are based on facts, not emotions, by an arbitrator who understands the law and the responsibilities of the long-term care facility. As such, the arbitrator helps prevent runaway verdicts and provides a fair and more predictable process for both sides. And as we said earlier, arbitration tends to be less expensive for everybody involved. Here's two more cases, and then we'll move on. Ledesma versus Mariner Health Central, which is in 2021. $13.5 million verdict with $9.6 million in punitive damages. That doesn't even include the award of attorney's fees that they would be entitled to. And here, the attorney's fees were over $6 million. And then Rios versus Pine Creek in 2023, $30.9 million in damages, and $25 million of that was punitive. You do not have what we call a cap on damages for an RCFE or a long-term care community. Healthcare providers are fortunate that they have a statutory cap. And what does that mean? That means that the legislature has decided that healthcare providers, when they get sued, there is a limit to the amount of damage for pain and suffering that the person suing can get. Unfortunately, for your communities, there is no such limit. As the plaintiffs or the family for the attorney for the family would say, the sky is the limit. That's why if it's a simple fall case, even though it sounds like a simple fall case, nothing is ever simple, because a jury of 12 can get swayed by their emotion and fear and by a skilled plaintiff's attorney to potentially find that you did something wrong and go one step further and award a verdict that is millions upon millions of dollars in damages, which could be devastating to your business. And we want to make sure that we give you the best tools to prevent that from happening. So how do we ensure that the arbitration agreement is enforced? Because that is really the point here, is not only to get the arbitration agreement signed, but it doesn't do us any good if we made mistakes along the way and that document you got signed is not enforceable. So how do we ensure that that arbitration agreement is indeed enforceable? One, read the agreement and become familiar with it and its terms. I know that sounds silly, but 90% of the people that I interact with that present arbitration agreements to the resident or the resident's family at the time of admission have never actually sat down and read the agreement. They thus have a lack of familiarity with it. Maybe they're intimidated by it because it looks like it was written by a lawyer and there's a lot of paragraphs and it just doesn't make sense. But if you sit down and actually read the agreement, you will see that the PCH mutual agreement provided to you and available for your use is very user-friendly. It's broken up into multiple paragraphs, and each paragraph is very self-explanatory. So read the agreement so that it is less intimidating, so that you understand what it says. And when you become more familiar with it, you will invariably be more confident with it and won't be intimidated by presenting it to the resident or the family. Make sure the correct person signs the agreement. That is the number one issue we see with trying to enforce these agreements. Oftentimes the wrong person signs, and we will go into a little bit later who should be the one to sign the agreement. Next, make sure all necessary documentation is obtained. And by that, we mean powers of attorney, advanced healthcare directives. If the resident is not signing the agreement as somebody else is, get that durable power of attorney, get that advanced healthcare directive, get the letters of conservatorship, find out if any of those documents exist, and make sure we have them for the file. Next, the arbitration agreement you receive will probably have some blank lines on it. Those blank lines are there for you to insert information that is specific to your community or facility. So please make sure that blank lines are correctly filled out. There tends to be a theme, which is blank lines are bad. So if you see a blank line, look at it and think a blank line is bad. What do I need to put on this blank line to make this agreement enforceable? And we will get into that in a bit. Finally, retain a color copy of the agreement in the residence file. So now you're ready to present the arbitration agreement. You've read it, you understand it, or at least you have a better understanding of it than you did before you read it. And now the resident or the resident's family comes in and the admission process is going to take place. Present the arbitration agreement at the same time you do the admission agreement. And what I mean by that is don't do the admission paperwork today and save the arbitration agreement for tomorrow or for 3 days or 4 days down the line. Have it as part of the documents that are executed during the admission process. You're far more likely when somebody is in the mode of signing all the admission paperwork to have the arbitration agreement signed at the same time because it's just another document in the packet of materials that they're reviewing. And you have their attention at that time, and that is the time and place to do it. We have had scenarios where an arbitration agreement was signed on day 3 of the admission, but a fall happened on day 2. And unfortunately, because the arbitration agreement was signed after the fall, and that arbitration agreement did not have what we call to be a retroactive clause, the arbitration agreement wasn't enforceable. So please, when you present the admission agreement, have that arbitration agreement as part of the admission packet so we get everything to be signed at or about the same time. You should also explain when you get to the arbitration agreement, something briefly about the arbitration agreement, and ask them if they have any questions about it and give them an opportunity to review it. Some of the key points that you're going to want to point out when you get to the arbitration agreement is, one, it's voluntary. It's not a condition of admission. Two, it has a 30-day revocation clause. And then three, you're going to give them a copy of the agreement that they signed, along with whatever other paperwork you will give them. So what to say to get the ball rolling? Because oftentimes this is what the question I get asked most from folks about, what do I tell people about the arbitration agreement? Do I have to explain every single paragraph? Do I have to read it to them? No, you don't have to go through all of that process. But what you should do is, like I said before, read it and become familiar with it. And then to get the ball rolling, when you get to the arbitration agreement, and sometimes I recommend even just printing this slide and having it someplace so that you can just read it. And after you read it a couple of times, you will develop sort of muscle memory, and you'll develop your own way of delivering this mini paragraph. And what this says is, this is our voluntary arbitration agreement, which can be rescinded within 30 days. It states that should a dispute arise during your stay here at the facility, that dispute will be decided by an arbitrator, a neutral third party, typically a retired judge with experience handling long-term care disputes, instead of being heard in a court by a jury. We find that arbitration is a fast and less expensive way to resolve disputes, which is good for everyone. It also protects your sensitive medical health information from the general public. Please review the agreement and let me know if you have any questions. Oftentimes, folks are familiar with the term arbitration and they know what it means. But what we run into with enforcement issues, in the old days, and when I say old days, when I still had hair and I was trying to enforce arbitration agreements could just be part of the paperwork somebody reviewed. You didn't have to explain it. You didn't have to draw attention to it. If it was signed, that was good enough and that was enforceable. But the law has changed, and now the courts want to see that the elderly population, which is considered to be a vulnerable population, are not being taken advantage of and are not being misled or tricked or coerced into signing an arbitration agreement. So they want there to be evidence that the agreement, at least the key portions of the agreement, which to the law is it's voluntary and can be revoked. Those are the key portions, that you at least let that be known to the resident or their family that here's the arbitration agreement. It's voluntary. You don't need to sign it. If you do sign it, it can be revoked within 30 days. But we think it's a good idea to sign because arbitration tends to be a lot faster. Your private information is sensitive. Your private sensitive information is protected from the general public. Please take a minute to review it. I'm happy to answer any questions you've got. And that is often enough for someone to then sign the arbitration agreement. And like I said, you will develop your own sort of comfort level with what to say and what to convey. This paragraph here is just a sample way to get the ball rolling, and it touches upon the key issues, that it's voluntary, that it can be revoked within 30 days. The arbitrator is typically a retired judge, and then you're asking them to review it and let you know if they have any questions. If you don't say any of this, what will happen when we move to enforce this arbitration agreement, the attorney for the family, if they're a good attorney, will take your deposition and they'll ask you, what did you tell the family about arbitration when you got to the arbitration agreement? And if you said, I didn't tell them anything, I just handed them the document, that's going to be a problem with trying to get this enforced, especially if the person is advanced in years, maybe has fluctuating capacity, maybe can't read very well, maybe is tired upon admission because it's been a long day. And it's a 5-page arbitration agreement. So they want to make sure that if you are able to testify, I do have a routine that I go through when I get to the arbitration agreement. And that routine is to explain to residents that the arbitration agreement is voluntary and that if you sign it, it can be revoked within 30 days by letting us know you want it revoked. and that arbitration is heard by an arbitrator who's a neutral third party, and it won't be heard in court. Instead, it'll be heard by the arbitrator, and that their private, sensitive medical health information will be protected from general public. And then I ask them to review it. And if they have any questions, I ask them to let me know and I'll try to answer those. That's what I tell them. A judge will hear that and they'll say, okay, there's no trick. There's no fraud. You didn't take advantage of this person. You told them what they needed to know, and they knowingly and voluntarily entered into this agreement. And that will go a long way to getting that agreement enforced. So does it matter who signs the arbitration agreement? As you can all imagine, the answer is a resounding yes. Most arbitration agreements are invalid because the incorrect person signed the agreement. I can't tell you how many times a community will get sued and I will ask, do we have an arbitration agreement in the file? And the person says, yes, we do. And I kind of get excited because I'm like, great, that's good news for you. We'll get this into arbitration. We'll take it out of the jury system. It'll be a more fair environment for the duration of this litigation. The arbitration agreement shows up and I look to see who signed it, and it's now not enforceable because the incorrect person signed it. So who should be the one to actually sign it? Gold star first choice is the resident. This slide too, if you're going to print up slides, should be a slide that you print up, because it doesn't do any good to have an arbitration agreement signed if it's not signed by the correct person. Gold star first choice, the resident. If the resident cannot sign for whatever reason, if they're incompetent, if they have fluctuating capacity and they're at a point in time where their capacity is such that they cannot make their own decisions. The second choice is the general durable power of attorney agent. So whoever that durable power of attorney appoints as the agent, that's the next one. Or the financial power of attorney, or the court appointed conservator. Just 3 or 4 years ago, a healthcare power of attorney would have been the second choice, but the law has changed and it's no longer the second choice. It is now the third choice. A healthcare power of attorney by itself typically does not confer the power upon the agent to bind the resident to the arbitration agreement. But not all healthcare powers of attorney are created equal. Some are very narrow and they only allow the agent to make healthcare decisions. Some are broader and they include other powers, such as allowing someone to sign admission contracts and to handle litigation disputes. If we get lucky and this is a broad healthcare power of attorney, then the healthcare power of attorney is sufficient for our purposes to enforce the arbitration agreement. But more often than not, when somebody has a healthcare power of attorney, it is a narrow one designed only for making healthcare decisions. And law and the courts have ruled that entering into an arbitration agreement is not a healthcare decision. It is a waiver of your constitutional right to a jury trial, and thus a healthcare agent cannot make that decision for the resident. It has to be a general power of attorney appointed agent or a financial power of attorney appointed agent, unless you have a broad healthcare power of attorney. So that's why we've got the order here. First, the resident. Second, general power of attorney or financial power of attorney or court appointed conservator. If you don't have any of those first two, then we'll take the healthcare power of attorney. And also, if somebody's got a healthcare power of attorney and they went through the process of doing that, there's a good likelihood that they also have a general durable power of attorney. They probably had them both done at the same time. So these are questions, whether or not you present an arbitration agreement, you should be asking the resident or the family for anyway. Are there any powers of attorney? And if they say yes, and they bring you a financial power of attorney, ask them if there's a durable power of attorney or a financial power of attorney. It's good to have all of those for your file. Now, what if we don't have any powers of attorney and the resident is incapable of signing? Well, the fourth choice would be the responsible party, which I'm sure you're all familiar with that phrase, and it's typically a spouse or an adult child or a grandchild, an adult grandchild. A responsible party signing an arbitration agreement typically does not make the agreement enforceable. But the reason why that is our last resort is because I have seen many, many times where a responsible party will sign the agreement because that responsible party did not know if there was a power of attorney. And when the lawsuit happens and we start subpoenaing medical records, sometimes a power of attorney will be in the primary care provider's medical chart. And the responsible party had no idea that that power of attorney ever existed. And that power of attorney appointed that very responsible party as the agent. So now, while that responsible party didn't know they were an agent, doesn't change the fact that they were. And so having that responsible party gives us the hope of being able to find an arbitration agreement sometime downstream to make that arbitration agreement valid and enforceable. So a signed agreement is better than no signed agreement. So again, if you don't have the resident, you don't have a general power of attorney, a financial power of attorney, a conservator, then the healthcare power of attorney. If you don't have any of that, please get the responsible party to sign, and it still might be enforceable down the road. And finally, you as the facility representative should sign the agreement. There should be a blank line for you. And again, that goes to the theme of blank lines are bad. If there is a line that says facility representative, signature, don't leave it blank. Please sign it. If there's a line for a date, please don't leave it blank. Fill in the date. So let's go with a couple of scenarios here. And I'm not quite certain how many folks we have with us today, but when I'm done reading this slide, if you want to unmute yourself and chime in and try to answer this question, I'd love to hear it. What if the resident is alert and oriented, yet they want someone else to sign the arbitration agreement for them? We see this from time to time, actually. The resident has been transferred. The move is sort of stressful. It's been a long day. They're tired. And they don't really want to deal with this right now. And instead they say, I want to go to my room. My son or my wife, she can take care of all of this for me. What would you do in that scenario? Does anybody want to unmute themselves and take a crack at answering this question? Okay, so it's kind of a tough question sometimes because you might be thinking, okay, I will have the wife sign because the resident said it's okay to have the wife sign. But then think about what I get 2 or 3 years down the line when the family ends up suing. I get an arbitration agreement that is signed by the wife. When the resident is capable and competent to understand and make their own decisions according to the H&P that is filled out by the physician. Now I have an unenforceable arbitration agreement. So what do we do in this scenario? In this scenario, we should document, and that just means write down in the chart that the resident gave verbal consent to have the wife or somebody else sign the admission and arbitration agreement on their behalf. It could be something as simple as resident, put in the resident's name, advise that his wife, put in the wife's name, can sign the admission agreement and arbitration agreement. Date it, you sign it, have the wife or whoever the resident wants to sign the rest of the paperwork, sign it. And then tell the resident, I know you don't want to sign any of the paperwork, but for me to have your wife sign all of this stuff, I at least need you to sign the note that says, that I'm writing right now, that says that you gave authority for your wife to sign the admission and arbitration agreement. And then have them sign it. So now I've got this note that is signed by you, signed by the person who signed the arbitration agreement, and signed by the resident. all around the note saying that authority was given for this wife or this responsible party to sign the agreement. That will be huge to try to get this enforced. Because now when I show the court, Your Honor, I've got this arbitration agreement. It's signed by the wife. And the other side will argue, Your Honor, there's no power of attorney. The wife doesn't have the authority to sign this agreement. She's not his agent. The agreement's not enforceable. It'll give me an opportunity to then show the court, Your Honor, I have this note here that is signed and dated the same day, this arbitration agreement that is signed. And it's signed by the resident, acknowledging that he verbally gave consent to his wife to sign the arbitration agreement, and then his wife signed it. That will go a long way to showing that verbal consent was indeed given. And verbal consent, a resident can give in order to create agency. And agency is what is needed to confer upon that responsible party the power to bind them to the arbitration agreement. So documentation, the kind of note that we're talking about, is useful evidence to establish that the person signing the arbitration agreement had express authority, meaning power given to them by the resident to sign it on the resident's behalf. The court will give this type of evidence great weight in determining if the arbitration agreement is valid and enforceable. And a petition to compel arbitration is generally filed with the court several months to several years after this document is signed. So without this document, it's nearly impossible for people to remember what occurred at that time of the signing. And I do see this a lot. I see somebody resided in, let's say, your community for 3 years, and then they had a fall, and the fall resulted in a fractured hip. And they elect to sue your community. Well, they have 2 years, according to the statute of limitations, to do that. And so then when they sue your community 2 years down the road, maybe the person who presented the admission paperwork and the arbitration agreement are no longer with your company. So we can't track this person down. They've sort of fallen off the grid, or even if we do track them down, they don't want to cooperate. So now we've got this arbitration agreement signed by somebody other than the resident, and we don't have any power of attorneys in the file. And we have no way of tracking down whether or not the person who presented the agreement was told verbally by the resident that this responsible party could sign on their behalf. But if we have a note in the chart and it's signed like this, then that's great. We present that note as evidence to the court. And what I've seen so many times, I will see a declaration from the family member who signed the arbitration agreement, and they'll say, Your Honor, I declare under the penalty of perjury that I have never been my husband or my loved one's agent by way of a power of attorney, and they have never, ever given me the power to make decisions on their behalf or sign arbitration agreement or this admission agreement. I only signed this because I thought I had to. But when we have a note that is signed by that very person, and that note says that they acknowledged that they were given verbal authority by the resident to sign on their behalf, immediately they look like they're lying before the court, and their credibility is tainted, and it helps us enforcing the arbitration agreement. So please, if the resident is too tired to sign or doesn't want to sign it and wants somebody else to sign, if you're going to comply with that request, please make a note that that request was made, have the resident sign it, you sign it, and whoever they're giving the authority to sign it. And again, it could be something as simple as, Mr. Jones, I understand you really don't want to deal with this paperwork and you want your wife to sign everything, but I do need you to sign the little note I'm making here that says that you consent to allowing your wife to sign the admission and arbitration agreement on your behalf. If you get that, you sign it, and both of them sign it, we have a high likelihood of getting this arbitration agreement enforced. Okay? But you have to include the words arbitration agreement in that note. If you say admission packet, that's not good enough. If you say admission agreement, it's not good enough. It has to include the words arbitration agreement. So admission agreement and arbitration agreement, because that resident is giving the power to do both So you might as well include both in the note. What if there is a power of attorney document? Well, actually, let's go back real quick. Let's go back to this one. Another thing you could do, if the resident is competent, and they might just need a little time to settle in, maybe come back to them in an hour or two and present them with the admission paperwork. It depends how firm they are on having someone else sign on their behalf. But, if they go to their room and relax for a little bit and you say, Mr. Jones, why don't you go to your room, unwind, relax, we'll come back in a few hours and we'll do the admission paperwork then. You'll probably get an, okay, that sounds good. And then you go through the admission paperwork and now you've got the gold star. You've got the resident actually signing the arbitration agreement. So let's move on to the next hypothetical. What if there's a power of attorney, but like the family is aware there's a power of attorney, but they don't have a copy of that document at the time of admission? What do you do then? A lot of times people will say, okay, well, today's the admission day. I'm going to get all the admission paperwork signed. Just bring in the powers of attorney, next time you guys come in. Well, what will happen is you will have somebody signing all the admission paperwork today, the arbitration agreement today. And 3 or 4 days later, that power of attorney gets brought in and added to the file, and nobody takes the time to look at that power of attorney. And that power of attorney appointed somebody else as the agent, but somebody different signed the arbitration agreement. So now we've got a signed arbitration agreement and a power of attorney, but the arbitration agreement's not signed by the person who has the authority by way of the power of attorney. Now it's not enforceable. So these are all sort of little tricky scenarios, and it does require a little due diligence on your end, again, to make sure that these are enforceable. So if you have somebody sign the admission paperwork and the arbitration agreement on day 1, and you get the power of attorney on day 3, day 5, day 8, please look at that power of attorney. Please read it and see who is designated as the primary agent. And when you see who is designated as the primary agent, go back and look at that arbitration agreement and see if the person who signed the arbitration agreement is listed as the primary agent on that power of attorney. If that primary agent on the power of attorney did not sign the arbitration agreement, get that primary agent to sign a new arbitration agreement. And what you can do is you can present the arbitration agreement to that agent and say, when your loved one moved in last week, so-and-so signed the admission paperwork, including the arbitration agreement. But by looking at the power of attorney you brought in, it designates you as the agent. We need you to please sign the arbitration agreement that was previously signed, or can you sign it as well directly above or below the signature of the agent, of the person who signed previously. That way we've got the correct person's signature on the document. Okay. Otherwise, I have a arbitration agreement signed by somebody who's not the agent by way of a power of attorney, and all your good work of getting it signed, it's signed by the wrong person, and now it's not enforceable. The other thing to look out for is you might see the power of attorney appoints a primary agent and an alternate agent. And the person who signed the arbitration agreement is the alternate agent. So you're like, great, I got the alternate agent signature. Unfortunately, the alternate agent's authority is only good when the primary agent is unavailable or revokes their right to be the primary agent. And in today's modern world, the courts view unavailable to be something akin to in jail or death. If you live if the primary agent lives in a different state, we live in the modern world with FaceTime and email and cell phones. They're not unavailable, Mr. Healy. Your client just has to go an extra step and pick up the phone or send an email. That's what the court's going to say. So when somebody brings in a power of attorney to add to the file, please read it. Please see who is designated as the primary agent. And please, interact with that person, if at all possible, with regard to getting the arbitration agreement signed. The primary agent may not be necessary to have the admission agreement signed, but for the arbitration agreement, it is. So again, if you've got an arbitration agreement signed by somebody who's not that primary agent, and that primary agent is around and available, reach out to them and say, the power of attorney that was provided to us designates you as the primary agent. The arbitration agreement was signed by your sister or your son, and unfortunately, we need you, the primary agent, to be the one to sign this document. Can you please sign it as well? And oftentimes we'll find that that person will sign it, and now all of our bases are covered. Okay? Another scenario that we tend to see: what if the person signing the agreement is the responsible party and not the power of attorney, and the resident's incompetent? Now that goes back sort of to the first question and answer hypothetical. We have an incompetent resident. Now, last time the resident had the capacity to understand and make decisions, but didn't want to deal with it because they were too tired. But they consented to have their loved one sign the paperwork. Here, we can't get verbal consent from the resident because the resident is already incapacitated. And we don't have a power of attorney. So what do we do in that scenario? That's when we have the responsible party sign the agreement. That goes back to that slide that had the gold star: first choice, second choice, third choice, fourth choice. This is a fourth choice scenario. We get the responsible party to sign the agreement because we never know if down the road we will find a power of attorney that appoints that responsible party as an agent. So if the resident is not competent to consent, what you still should do is ask that responsible party. For example, if I am signing paperwork for my mother who I am admitting into your facility, you should ask me, do you know if there's any power of attorney? And I say, I don't think so. I've never seen any. I don't think any exist. Then you should ask, during the time frame that your mom was still able to make her own decisions, did you guys ever have a conversation about if something should ever happen to her or she lost the ability to make her own decisions, if somebody had then the power to make decisions for her? Because a lot of families will have those sort of discussions. I know I have. I've told my kids, if something ever happens to me, here are my wishes. And, I want this child to make decisions for me. You're my first person. And if you're not available, then, this other child will make decisions on my behalf. If they tell you they've had that kind of conversation, document it, just like we documented the thing before. Write on the note. All you have to say is, okay, I just need to document that for my chart, that the resident advised when they were capable and competent, that they had said to you that if they ever lose capacity, they want you to make decisions on their behalf. Then date it and sign it and have that responsible party who told you that sign it as well. That will help us try to get this enforced. Okay. Another document that you might be seeing, and it might be rolled out and available to you in the near future, is a declaration of agent form, which is designed to address this very issue when it arises. And what the resident agent declaration form says is, it's basically what it says. It's a declaration. It says, this declaration is executed by, and there's a blank line for that family member to write in their name, or for you to write in their name. And it says, I declare, meaning this family member is declaring, that I, the family member, is authorized to make all legal decisions for resident's name. Write in the resident's name. On or about, and here's where you put like December of 2020, the resident requested that I make all legal decisions on their behalf. So whenever this conversation took place between the family member and the resident, where the resident said, if something ever happens to me, I want you to make decisions for me, that's where you would put that in on that blank line, the month and the year. And then the rest of the document goes on to say that I've been making decisions on their behalf pursuant to their consent, and I agree that the above is truthful and accurate under the penalty of perjury, and they sign it and date it. So this is a very useful form when and if it's used. And again, this form really only comes into play when you've got a scenario where you don't have the gold star of the resident signing. You don't have the general power of attorney or healthcare power of attorney. Sorry, general power of attorney or financial power of attorney or conservator signing. You might want to use this when you're having the financial power of attorney sign. You might want to use it when you're having the responsible party only sign. Okay? Why document it all? Documentation helps the recollection of events. It creates a contemporaneous record of events and is a valuable tool to increase enforcement. You're not going to remember every admission you do throughout the years. Having documents and notes that are part of the residence chart are important because they will invariably have information in there that you or your staff might forget. And make sure it gets added to the chart, not some miscellaneous file that you might have somewhere else, because miscellaneous files tend to have a way of disappearing. If it's added to the residence chart, then we know it's there for safekeeping. All right, spotting errors before the agreement is executed is very important. Okay, so let's look at a sample here. When we have a very active group, this is an interesting sample because everybody points out something that I always tend to miss. But when I first looked at this, I missed the obvious. And the obvious, what is the mistake? And if anybody wants to unmute themselves, point out what the mistake is, please. The mistake is we've got an astronaut standing on the moon, and in the backdrop is the moon. And then somebody else said the flag is waving, which makes it look like wind, and there wouldn't be wind on the moon. That went a little beyond what I was expecting. But obviously, this is sort of to get your mind warmed up to identify the mistake. So here's a sample arbitration agreement. This is not the PCH mutual agreement. So I will see arbitration agreements come across my desk like this. And on the left-hand side, we have resident name. And this person put in the resident's name. That's great. Sometimes I get a blank line with no resident's name. And I know it sounds silly, but a court sometimes will not enforce the agreement because they look at what's called the four corners of the document, the actual piece of paper, because it is a separate contract. And if you do not have the resident's name on the separate contract, they will say the resident is not a party to this agreement. Even if I have a declaration from you that says, I gave this to the resident signed it during their admission process. Some courts like arbitration, some don't. And if you have one that does not, they will say, Mr. Healy, your client, this is their document. If it didn't matter to them to have that resident's name put in there, why should it matter to me? So please, remember the theme. Blank lines are bad. Article 2, there's a blank line. It's not filled out. That is where you put the facility name. If you don't put in the facility name, a court can say, Mr. Healy, your client did not put their facility name there. It's not enforceable. Sometimes whoever fills out this document, they'll write on the blank line the facility name, but they'll shorten it. They'll put Bay Area Rehab, but that's not the correct legal name. Please be sure to put your correct community or facility name on that line. If you put the incorrect name, you're giving them an opportunity to try to get out of this agreement. Page 2, facility representative signature line is not signed. That's a problem. Then you do have this resident signature line underneath the all capital advisory. But if you look down, there's another all capital advisory with another line for the resident signature, and that line's not signed. Again, blank lines are bad. I know it's a very simple theme, but it's a very important theme. So if you come away with a couple of things today, keep that in mind. Blank lines are bad. Please do not have your arbitration agreement be permitted to have blank lines. Fill them out. In this scenario, the first clause says medical malpractice is subject to arbitration. The second clause, that's not signed, says that all other claims are subject to arbitration. Well, if it's not signed, elder abuse is not going to arbitration. General negligence is not going to arbitration. And those are the main causes of action that you're going to get sued for. So please, blank lines are bad. Get them filled out. Here is the sample PCH mutual arbitration agreement. Again, we don't necessarily have the time to go through all of this in detail, but it is very user and reader friendly. As you will see at the beginning on the left-hand side, there's blank lines. Again, fill those out, okay? It says the term resident in this agreement refers to, put in the resident name. The term facility in this agreement refers to, put in the facility name. Okay, those are the only blank lines you have to deal with on the first few pages. And again, it's very self-explanatory. When you read it, it will make sense. And I'll be very quick. Article 1 says, it is understood that any dispute as to medical malpractice is going to arbitration. Article 2 says, it is understood that any and all other disputes, controversies, or demands, including elder abuse, is going to arbitration. So it's broken up into digestible chunks that make it easy to understand. The third one, Article 3, this is voluntary. It's not a precondition. Article 4, you acknowledge that all claims are subject to arbitration. So if you actually read it, you'll find it's digestible. And if for some reason you read it and you say, you know what, I don't really know what that means, my contact information will be on this slide. And so my cell phone number and my office number, an email, you can call me anytime and I'll be more than happy to answer any of your questions. And if a family asks you a question, which almost never happens, what does this mean in Article 6? And if you don't know, be honest with them. Say, I'm not really 100% sure what that means, but I will look into it and I will get back to you. And then give me a call and I'll happy to answer that question so that you can provide them with the information they want in order for them to sign. Okay, so what do we have here? More blank lines. Okay, all capital section on the right in red, blank lines. Fill those out, please. Okay, now we have the same thing on the last page. They are different. This one in red has to do with medical malpractice. This one in red has to do with everything other than medical malpractice. So it goes back to this type of agreement where they signed one, but they didn't sign the other. You want to make sure you have both. Facility signature, resident signature. Facility signature, resident signature. Okay. Now, if you're having an agent by way of a power of attorney sign, facility signature, and the last one only, residence, agent, and individual signature. Okay? The only person who signs for the resident signature is the resident. If somebody other than the resident is signing, a power of attorney, a conservator, a responsible party, they sign on the line that specifically identifies them, residence, agent, and individual. Same on the second page. They sign on that line. So the resident would sign twice, there and there. And if the resident doesn't sign, their agent responsible party would sign twice, there at the bottom and there at the bottom. Okay? Again, blank lines are bad. So please try not to have blank lines. The only blank line you would ever have on this agreement would be the resident's signature line would be blank if somebody other than the resident is signing because they're signing on the resident's agent's line. Here's my information. I'll leave this up for 30 seconds or so you could jot it down. It has my cell phone number. It has my office number, and that's my email address. I am always happy to help. I've been doing exclusively long-term care, healthcare, defense work for 24 years. And arbitration agreements are a tool to level the playing field and to ensure that folks like yourself and communities like yours who are in the business of helping others can continue to be permitted to do so because you're not being taken advantage and given a crushing verdict by a jury of 12 who does not understand the rights, obligations, duties of a long-term care provider such as yours. We want to make sure we get you in arbitration before an educated arbitrator who knows the law, who knows the facts, and who can be fair, with their rulings. That's all we ever want of our judicial system. And unfortunately, when we start dealing with complicated matters that involve long-term care communities, sometimes we don't get that. But getting us an arbitration definitely helps that process and might save you one day from having a multiple $1 million verdict. Hopefully that day will never come. Here are some more resources that are free to PCH members. And so please take an opportunity to use these resources because, again, PCH Mutual and our office wants to help you in any way we possibly can to make your business more successful and protect it from folks who might try to do you harm through the legal system.
Thank you, Jeff. We have a couple questions, which I thought maybe could you take a second to answer a few?
It would be my pleasure.
So the first one is someone mentioned that they had an arbitration agreement, but the court dismissed it because it implicated the claim implicated elder care and elder rights statutes. Is that because the arbitration agreement must reference that that's being waived, or those type of claims would be put into arbitration, or do we know what happened here?
Well, there's a couple of scenarios that can happen there. An arbitration agreement is a contract. So when the court looks at an arbitration agreement, they read it and they look to see what it says goes to arbitration. Sometimes you'll have an arbitration agreement, depending on who it's written by, that will say all claims are subject to arbitration. And oftentimes that is sufficient. But sometimes, kind of what I showed before, let me go back to this one. I suspect this is the scenario that you had. You probably had the resident's name, the facility name. I suspect you had a signature on one of the lines, but not the second line. Because most arbitration agreements, according to statute, if it has a clause calling for medical malpractice to be adjudicated in arbitration, there needs to be a separate signature line for sending medical malpractice to arbitration. That's why there's two separate signature lines here and two separate all capital advisories, is because the statute calls for it. Otherwise, we would just have one signature line that covers everything. But in California, we have to have a separate signature line for medical malpractice disputes. What I suspect happened is your arbitration agreement had this slide, and that the person signed for medical malpractice disputes, but forgot to sign, or the admissions person omitted to have the resident sign that second all capital advisory that calls for all other claims, which would include elder abuse and neglect. So if they did not sign that second signature line, then the court would say, yeah, we're not sending we're not sending elder abuse claims to arbitration because they signed the line calling only for medical malpractice to go to arbitration. Mr. Healy, there's no medical malpractice claim pled here. There's an elder abuse claim. So that is probably what happened. But if that's not the scenario, then it's because the language of the arbitration agreement, whoever wrote it, may not have been as detailed as necessary to include elder abuse claims. Now, we're fortunately here with the PCH Mutual agreement that is available to the members. It covers that base. We've got Article 1, which calls for medical malpractice, and you've got Article 2, which calls for any and all other controversies, disputes, or claims that relate to or arise out of their residency at the facility. And it specifically says, including negligence, wrongful death, intentional statutory cause of action, including but not limited to the Elder Abuse and Dependent Adult Civil Protection Act, i.e. elder abuse claims. So if you are using a arbitration agreement, again, you're more than happy to send that to me, and I will give you my review and let you know what I think of it. I've already reviewed the PCH Mutual agreement, and I find it is exceptionally solid and a good tool to use. So you might want to consider replacing the one that you have been using and potentially using this one.
And Jeff, also, someone else asked, do the Durable POA or Advanced Healthcare Directive need to be notarized?
That I think is, gosh, I'm trying to think here.
Yeah.
I believe they do. if I recall correctly, there's two types of scenarios. There's ones where they could be witnessed by two independent witnesses, or it can be notarized. Most people tend to get them notarized. Notarized is the best way to go. At the end of the day, that is really not something that we are going to be presenting to the family. They should already have that document completed, or they will go get that document filled out. But typically, powers of attorney are notarized.
Okay. Finally, someone else asked, does every separate page have to have the names of all the parties that are agreeing to sign the document?
No. And so this is a contract. And so what you'll have is it's called a standalone contract, meaning it is not something that's buried in a bigger document. This is its own separate thing. And because it is its own separate contract, you don't need people to initial or sign every single page. So when you use a contract like this, again, blank lines are bad. Put in the resident's name at the top where the blank line is there for the resident's name. Put in the facility name where the blank line is there, and then just make sure the correct lines are signed, and you are good to go.
Okay, and Jim Nacero, do you have a question? I unmuted you. I saw you raised your hand. Or has it already been?
I got a question, and call me naive. If a prospective resident is not forced to enter into a new community where the community requires an arbitration agreement, why wouldn't that AA be enforceable or unenforceable later down the line?
I'm not sure I quite understood your question. Can you repeat it?
Yeah, if a prospect resident is not forced to go into a new community that requires an arbitration agreement to enter into the community, why wouldn't that be enforceable?
I think where I'm getting lost is the negatives there. You said a resident who's not being admitted to a community.
No, I think why can't we require it? Why can't we, even though it's not a contract of adhesion, because they could pick another facility, but
yep. So that's a very good question. And so it's sort of a risk analysis determination here, because in RCFEs, unlike skilled nursing facilities, an arbitration agreement is not, skilled nursing facility and healthcare providers, you cannot make the arbitration agreement mandatory. It can be mandatory for an RCFE. It can be a clause, a paragraph or two or three in the admission agreement. It does not have to be a separate standalone contract. It does not have to be voluntary for an RCFE. But we believe you're far more likely to have it enforced if it is voluntary, because over the 20 plus years that I have been doing this, I have seen almost every argument you can imagine from the other side to try to invalidate these arbitration agreements, because plaintiffs' attorneys don't want to be in arbitration because they know they're likely to get a more defense-friendly, and by defense-friendly, I mean fair outcome, a fair view of the facts than what a jury will give. So they fight arbitration tooth and nail. Now, when you try to enforce a mandatory arbitration clause that is contained within a larger admission agreement, they will argue that that arbitration clause is unconscionable. That is a legal term, which essentially means unfair. They are going to say that this is a X number of page admission agreement, and buried in that larger admission agreement is this arbitration clause that is mandatory. So the big, powerful corporation gets to dictate to the vulnerable elderly adult that they have to arbitrate and they can't say no to it. So it's pushed upon them. And a lot of courts will look at that and say, you know what? That is procedurally unconscionable, meaning there's something sort of inherently wrong with mandating that somebody waive their constitutional right to a jury trial in order to live at your community. That does not sit well with most judges. So once upon a time, I used to actually put arbitration clauses in RCFE admission agreements, but I found that they were getting harder and harder and harder to enforce because the courts were finding them to be unconscionable and unfair. Once we separated them, same language, but put it in a separate contract, then the courts found them a little less unconscionable, but still said we were making them mandatory. So the way to get around that was by making them voluntary. And once they're voluntary, their unconscionability argument the vast majority of their unfair unconscionability argument dies on the vine because it's voluntary. They can revoke it. But we still find if it's presented as part of the admission packet, you'll still get upwards of 95% compliance with people signing it. And now we've taken away that unconscionability argument, and we're far more likely to get it enforced.
Thank you, Jeff. And in the final two questions, I believe I can answer. There is a sample arbitration agreement on our webpage. I believe you can just download it right off of the page. It's the agreement that Jeff went through with us today. We will also be posting a recording of this webinar, which you can review at your own, at your leisure. And if you want to review certain portions, that would be great. That will also be on our website. And I believe that's everything. I want to thank everyone so much for joining us, and a huge thank you to Jeff and Kathleen for sharing this incredibly important information with us today. They do wonderful work at Lewis Brisbois and have us protected before litigation and after if needed. So thanks once again to Jeff and Kathleen.
Thank you, Laura. Thank you, everybody.
Thank you.